If we haven't met before, I'm Sarah, an end-of-life planning advocate, normalizing conversations about end-of-life and estate planning before those conversations are necessary. There are approximately 1 million questions that you and your people need to ask and answer before, near, or after your death or incapacitation about what should happen to you, your body, and your stuff. I know that's totally overwhelming, so here are 2 related videos. This one for questions to ask yourself about your potential incapacitation, and the other 7 questions to ask yourself about your eventual death and your estate plan, which will be linked above and in the description. If you answer these questions, you only have about 999,989 questions to go. Maybe the only thing harder to consider and plan for than the reality of your eventual death is your potential incapacitation. The example that is always used in law school is you're hit by a bus and you're in a coma, but it could happen in a million other ways. You will die. That is a 100% certainty, so while you may not exactly enjoy estate or end-of-life planning, you're at least considering something that one day you will need and will impact you and your people. Your incapacitation, on the other hand, is a big old maybe. Maybe you'll need it, maybe you won't. And it can be a bummer to think about, which combined makes it a little too easy to ignore. But unfortunately, if the situation arises, it can be vitally important that you've made plans for your incapacitation, especially when you're young. What medical interventions you may want as a 20-year-old may look very different than those of an 80-year-old. I always think of it as akin to taking my Red Cross first aid recertification class every few years. I'll do the work, but I hope I'll never need it. But hoping you'll never need something is rarely a productive planning strategy. So while you can hope you won't need it all you want, it's also important to spend time considering your potential incapacitation. The first question to ask yourself about your potential incapacitation: who will make medical choices for me if I can't? The answer to this question hinges on if you've appointed someone as your healthcare agent. How this is done and what specific form is used varies by state. It could be done via an advanced care directive, an appointment of healthcare agent form, appointment of healthcare proxy form, or appointing a medical power of attorney. The forms vary by state. If you've appointed someone to make medical choices for you in an advanced care directive or some sort of appointment of healthcare form, consider if that is still the person you want to be making medical choices for you. If you've never appointed someone to make medical choices for you, the person who will make those medical choices will be determined by law. That person will likely either be your spouse if you're married, or your nearest blood relation if you aren't, or a guardian or conservator appointed by the court, potentially a person who's a stranger to you. A very important note here about friends and unmarried partners. In most cases, friends and unmarried partners won't be able to make medical decisions for you if you haven't done the paperwork. If you are in a committed but unmarried relationship or are surrounded by friends and chosen family, estate planning is vital to ensure the people you want to be involved in your care are able to do so, even if they aren't tied to you by blood or marriage. The second question to ask yourself about your potential incapacitation: what medical choices do I want made if I am incapacitated and cannot speak for myself? What medical care you do or do not want in case of incapacitation should be documented in the living will or the living will section of an advanced care directive. Again, which form is used varies by state. Completing the living will ensures your person and your medical team understand your values, your choices, and your preferences. Making medical decisions for someone else in a medical emergency will always be difficult, and your people will have to live with knowing they made those decisions. When you've documented your wishes and talked to your people about what you want and what you don't want, they will have the information and the guidance that they need to make those decisions, which will make those decisions that much easier. One common objection some people have for not completing a living will is that they don't know what medical choices they would want made in a medical emergency. I get it. It's a question I struggled with when completing my own advanced care directive. Well, I can't help you decide the specifics of what medical interventions are right or not right for you is a conversation you should have with your doctor. But in my experience, many people are a lot more clear on what they don't want than what they do. If you are struggling with how to complete your living will, consider starting with the two extremes, things you know you want and things you know you do not want. With those two goalposts in place, it can be a lot easier to work from there. The third question to ask yourself about your potential incapacitation: who will pay my bills? If you become incapacitated, your bills will still need to be paid. Your rent or mortgage, your insurance premiums, and everything else that is currently paid by you regularly. Do you have a way to make that happen? Depending on your situation, you can set up your bills to auto-pay or appoint someone as your financial power of attorney. The fourth question to ask yourself about your potential incapacitation: who will take care of my pets? You love your pet like family, but legally your pet is considered property. If you become incapacitated, who will take care of your pet? For temporary situations, an informal arrangement might work, but make sure you talk to the people involved to make sure they are on board. I had a friend who decided to leave me their fish. I don't know why they decided to leave me their fish. I don't like fish. I don't want to take care of fish, but I found myself with a tank full of fish. I did my best, but I did not mourn those fish when they were gone. A different choice could have been made for the fish. To ensure your pet is taken care of, you can create a pet trust to set up a framework for the care and financial support of your pet. And be sure to document information about your pet and how they like to be taken care of, so the person who takes possession of your pet will know how to best take care of them. I have a printable workbook for pet parents to document information about their pet. A link to that document will be in the description. If you found this video helpful, hit that like button and also consider hitting the subscribe button for regular end-of-life and estate planning information.